All right, good afternoon, everybody, or good morning, I guess. We are here for the task force meeting. I did want to inform everyone, Judge Garrett is unavailable this morning. She is traveling, so she will not be joining us. So I will be chairing with Stephen this morning. And like I said, I don't think we have a whole lot to go over other than to, I guess, update the use of the risk assessment and how things are going with pretrial. Stephen, was there anything other than that you thought we were going to address this morning?
No, that seems complete. We may want to just mention progress we've made on engaging community participants in the implementation review.
Okay. And that might actually be a good jumping off point, because that was an ongoing discussion we've had, I think, our last two meetings. And I know you and Judge Garrett worked on reaching out to a couple of folks. I think Shuli was one of them. And then I think you identified one other individual that may be willing to participate. Is that my understanding?
Yeah. You want me to report on that now?
Yeah, let's do that. Let's start there.
Okay. Suling Zhao, who is one of the coordinators of the development process with a county council contract for developing a racial equity commission, is interested in our work, but too involved in that to really commit time to helping us. If everybody recalls, we were looking for community members, people potentially from communities most affected by equity and disproportionality in the implementation of a pretrial risk assessment instrument, to work with us at the periodic evaluation points as Dr. Peterson feeds us data and we look at whether it's actually functioning in the ways that we hoped it would. So Suling is not available, but I was able to talk to someone that she and several other people recommended we contact, a young man named Adam Fryer, a person of color who is one of the case managers for the LEAD program through the health department under Melora Christensen. Adam is relatively new to Bellingham, a year and a half or so, but very engaged for the last year with LEAD on the ground activities, and obviously connecting with the one of the subpopulations in the pretrial release population. He's very excited to work with us. I think his LEAD experience will lend a good bit of perspective and considerable networking contacts as well as community contacts to our review process whenever we engage with that. And so he's fully at the ready to work with us. My conversation with Judge Garrett, and I'll mention this now to you, Judge Freeman, is that maybe the four of us, Adam, Judge Garrett, Judge Freeman, and myself, could get together just for an initial get-to-know session and background information session. And if we have others joining us, and I'll leave that to you, Judge Freeman, to report, maybe that could be a slightly larger group conversation. But at least we have somebody to contribute community perspectives, affected population perspectives on the rollout of the public safety assessment tool in our pretrial release decisions.
Thank you, Stephen. And I think back in July or August, we had a conversation with Judge Garrett, I believe, that as far as the timeline, and we decided not to have that conversation as of yet. I don't recall where we were at as far as when we anticipated bringing Adam in and having that conversation. I know we were putting it off for a little while. Do you recall a timeline?
I thought the idea was to wait until you had been able to make whatever contacts you might be able to make we're certainly not going to have the sit-down work sessions with Dr. Peterson's data. I think we were looking at like I said, sort of a get to know. Here's what we're really hoping to accomplish together, kind of preliminary discussion, and maybe that could be next month sometime.
Okay. And to update further on that last issue, as far as my contacts, I have had numerous conversations now with Dr. Johnson, and he's more than happy to join that group as well. He does have a lot of other obligations going on, which is why I haven't pressed as far as timing. But when we're ready, he's indicated on multiple occasions now that he's more than willing to help out and be involved. So I think once we present him with a time frame and kind of the outline of what we're looking for, that was his only requirement that going into it. So I think we could include Dr. Johnson and Adam in that conversation. And I think Judge Garrett is back, I want to say mid-October. So I will reach out to her when she comes back and set that up. Anything further on that topic from anyone? Right. Not hearing anything there. I can give kind of a general update on from the bench's perspective on how I've been seeing the pretrial services and the risk assessment tool in use. And then I think I'll kind of turn to Dave and maybe John for specifics as far as numbers and things of that nature, although Dave did just send me our current numbers, which I can report on. As far as pretrial monitoring goes, it looks like we have 70 in the medium category, 40 in low, and 14 in the high cases for 124 total. I don't have the numbers from this time last year, but I would suspect that those are down a bit. Just in conversations that I've had, and I did reach out to two of the three commissioners, and I had another conversation with the other probably 3 or 4 weeks ago on this topic. I don't think there's been quite as much use in the last few months of pretrial services. It's been reported that I don't think the state is asking for it as often, and neither is defense. They were seeing that more often, and so it really is when they initiate it from the bench as far as pretrial monitoring goes. The risk assessments tool has been back in use since I think before our last meeting. I have checked in with the commissioners with the use of the risk assessment. They are still reviewing it in every case. They receive it via a zip file when they receive all the other information going into first appearances. They are still reviewing that. Kind of mixed feelings and results about how effective and useful it is, but it's certainly a tool that they're using to almost kind of confirmation and reviewing their own, after they've looked at the criminal histories, they've looked at the charges, the FTAs. It's almost a tool to help them either confirm or dispute kind of what they've seen as far as the record. So it is still being used and reviewed in every case. Again, from what's being reported, I think the use of pretrial monitoring is probably a little bit lower. And I feel like that's an area that we should address as far as, whether there are ways that we can get more use out of this and be an effective tool. Certainly now that we are issuing bench warrants again for failures to appear, it seems to me that at least those low risk push notifications, things of that nature would be more helpful to a lot of folks. Now that failures to appear will result in a bench warrant if it's at the trial call. So I think I'll turn to Dave Reynolds and see if you have anything further on the numbers aspect of it and kind of where you see it. I would be curious if you know where we were at about this time last year on those numbers as far as monitoring goes.
I think they're down as well. John would have a better handle on what the comparison would be to this time last year.
Okay.
John?
Yeah, can you hear me?
Yeah.
Okay. Yeah, the numbers are down. Probably, I can't run them right now. We need a little time for the software to do it. So it takes a couple hours, just the way it works. So, but yeah, we are down probably 25% is a good ballpark figure right now from about a year ago. I think that's what you're asking.
Yeah.
Yeah. And hasn't really rebounded since. And, but we are maintaining right around, it was 124, 125. And most of them are in the category of medium. And right now, gosh, when we started the PSA, Judge Olson also changed some of the reporting rules for low medium are the same right now, you know, the COVID rules. So that just kind of gives you a little bit of difference there. But I mean, other than that, that's kind of where we're at.
And as far as the high risk category, do you have anything to report as far as any changes you've made with the reporting now, as things have opened back up a little bit?
Slowly trying to get them back in the office, unless of course there's some other issues, but they're still trying to make weekly contact as it's kind of been through this whole time. A little bit more face-to-face if they're local or something, but we had suspended face-to-face up until probably our last meeting. And now we're starting to see more face-to-face. And the numbers they're manageable. Right now is on high, it's 14, so that's manageable. So does that help?
Yeah, I think so. And I think what it would also be helpful is, you know, what the workload is like for those low medium cases, because in my mind, it seems to me now that the risk is a bench warrant again, you know, whatever we can do to help people, you know, remember to come into court. And if those push notifications are an easy solution, then it seems like we're underutilizing that a little bit right now.
The district court sending out court notifications still for us for each calendar.
Okay. And that's across the board?
I'll let Bruce speak to that. I've got certain calendars are doing it on anyway.
Okay.
Bruce, you have any comment?
Yeah, I do. Sorry about that. Yes, we are sending out text messages for all the calendars that we are receiving from Superior Court. And the only exceptions to that are on the pretty rare occasion, but on occasion it happens when our staffing is very low and we simply just we don't have the resources available to get those sent out. But I would say of all the calendars we receive, we're probably sending text message reminders to easily 95% plus for all the folks that we have contact information for.
Okay. Great. And maybe Maya can speak to this as well, but I would say that, you know, since the changes in the court rules and we don't have issuance of bench warrants on status calendars, I'd expected to see a few more, probably more warrants than what we're seeing on the trial call. I've been kind of pleasantly surprised that for the most part, people are appearing on trial call if they haven't appeared at status or they haven't been in contact with their attorney. We are seeing bench warrants, but I would suspect, and I don't know if Mr. Peterson can talk to this at all, but I would imagine that our bench warrant numbers are probably still down, even since it's opened back up for bench warrants earlier this year.
Just to address, I haven't been tracking as of yet, but we should get our next cut of data soon, and I can make it a point to pull those.
Okay. Thank you, Dr. Peterson.
Sure, of course.
Ms. Vanyo can correct me if I'm wrong here, but that's what I suspect, is that they're still lower than what we've seen in the past.
I think so too, but I don't have any numbers.
Yeah.
If any of the monitoring issues, and I would include within that category the possibility of bracelets of any sort, would benefit our pretrial services, but be running into financial budgetary limits. I'll just note that the task force as a whole is looking at this point in the budget development cycle for trying to put forward requests for funding that we think would advance some of the work going on within the task force. And this would certainly be within that kind of scope.
Yeah, Ms. Donovan?
Related to that, I know the numbers are really a small portion of our concern, but I had some specific questions about some of those high-risk cases. We've had a couple of situations recently with pretrial defendants in Superior Court with some really terrifying domestic violence situations, including threats and firearms and stalking behavior and frequently methamphetamine use, and including some defendants who've been able to post substantial bail and have been out and continuing to violate no contact orders with all those risk factors. And I'm just wondering if we could build in the capacity in limited circumstances, not as a broad initiative for all defendants, but when we have situations with those extreme kinds of risks, first of all, for referral to pretrial services after somebody has, or for the referral to happen simultaneously with bail setting, not necessarily as an alternative to setting bail, so that if somebody posts, there is monitoring that happens immediately. And then also for the court to have the option to use some of those other tools, such as GPS monitoring or urinalysis tests, specifically when there's a community safety concern. And again, I'm looking at high propensity for violence, firearms, extreme risk factors, and often specifically combined with meth use, where the drug use is, the concern is the safety risk. And I'm just wondering what it would take to have the capacity for the courts to make use of those kinds of tools, again, for those limited numbers with high risk.
I want to ask about it being used as an alternative. I mean, I see it all. I see pretrial services. Well, I haven't done first appearances in a while, but used in conjunction with bail, not as maybe they were intended as an alternative to jail. Can John speak to that?
We haven't had anybody sent with EHM or drug testing. At this point, we're just monitoring.
No, and I'm not talking about that because I don't think that drug testing would be constitutional, but I'm just talking about the pretrial monitoring is used in conjunction with the dollar amount. It's not people are getting, I think it's uncommon. Well, I don't know how common it is for people to get a PR with high level of supervision. It's usually like what I would see historically, it'd be like $20,000 bail and high level supervision.
Yeah, they come here with their PR'd or they have bail plus pretrial services assigned.
I don't think that's necessarily how it's supposed to happen, but that is what I've seen.
So I think you're both like, first of all, my understanding of last year was that it was utilized more in the sense that Ms. Vanyo indicated and what Ms. Donovan is kind of suggesting, that in addition to bail, it's been added. And I saw that more last year. In my conversations with the commissioners, though, I'll be honest, it sounded to me like that is not being utilized as much anymore. I know the intent was as a bail alternative, but we always viewed it as a, if there were specific circumstances, as Ms. Donovan indicated, that could still be a tool used in addition to bail as well, if bail is posted. And, just from what I saw last year, we were seeing that on occasion, specifically in domestic violence cases, is how I saw it. But in conversations with 2 out of the 3 commissioners today, I don't get the sense that is being done as often anymore. So that might be a topic of whether it is useful and appropriate, and if it is, then utilizing it more. As far as Ms. Donovan's other question regarding either GPS monitoring or other services or conditions, either John or Dave, do you want to speak to that?
Yeah, King County actually ran into this earlier this year where people were being placed on pretrial services and they were only being monitored Monday through Friday, 8 to 5, which really wasn't providing anything anywhere in the area of community protection on stuff. To really make that a useful tool, we're going to have 24/7 monitoring and ability if there's a violation to be able to immediately have the person arrested and brought in. So that takes a lot of resources in order to do that.
And Ms. Donovan, in experience in the municipal courts and using friendship diversion services, I do know the GPS monitoring is utilized regularly in DV cases, especially for prohibitions around certain areas. But I don't recall, I know friendship was very good about getting reports in very quickly, but it still was a 8 to 5 type reporting, correct?
Friendship diversion specifically does have the capacity to do 24/7 monitoring and to directly alert law enforcement of violations. That's been part of the contract in the small cities so far.
Okay.
I don't know about other companies or other services or what the county's options would be, but I know that Friendship has provided that.
Okay. And I know Bruce, if I remember correctly, district court still utilizes in-house as far as monitoring system, correct?
Yeah, we use the Sheriff's Office Jail Alternative Work Center for the district court clients, but we do monitor the friendship diversion cases for the municipal courts that contract with the county.
Okay. And as far as the reporting, you must get those, it sounds like Ms. Donovan indicated that they are available 24/7 as far as monitoring, but when they're actually reported, it's still, as Dave said, kind of an 8 to 5 thing?
It is for the cases that we monitor. That's correct.
Okay. And Dave Reynolds, as far as the possibility of that in the future and getting that off the ground, I think that was what Ms. Donovan was getting at, was what that would look like and what that would take.
Take a lot more staff,
Yeah.
For 24/7 coverage, and the ability to be able to get a warrant or whatever in the middle of the night or wherever we need it. I know some of the problems other jurisdictions run into in the past is you get this information, but there's no way to act upon it. And it's not necessarily preventative. Oftentimes you find out after the fact.
All right. And then I think finally, John, as far as workload and the ability to take a higher capacity of either kind of as they're set now, what is the capacity of your office as far as high risk cases?
We can handle more. Probably the max caseload with highs, you could easily double it. It starts getting pretty intense when you start having them checking in weekly, and if the numbers do jump, we'd like to get together to help adjust policy a little bit to post COVID and where we're at now, and those kind of things about reporting and realistic things, just kind of refine it since we started.
Right now, highs are once a week check-in, John?
Correct.
Okay. And that's shared between you and Alan?
Yeah.
Okay. We certainly could do more check-ins or more people checking in. Can you explain to the group what the check-in involves?
Oh, they come in either via phone, electronically, or in person. We just run through their background, make sure they know their next court hearing, and a couple other questions, see if any changes have occurred with their address, phone, text. So if their text has changed, then we've got to send that to probation so they get notified of their court appearances. That's kind of we've learned a lot through this, that a lot of the text numbers have been changing. So notifications aren't always going out to the correct number. Over 3 to 6 months, they might have another text number or phone. So, but other than that, they check in weekly, and we just run over some basic issues.
So it's pretty minimal.
Yeah, we just make sure they're in compliance with their conditions of release is really our concern.
Thanks.
It definitely sounds like there's more capacity for that. If there is any further discussion with our work group of expanding any services in the future, then to me, it seems like it might be a good idea to have a conversation either with Bruce, or I don't know if Bruce, is it still Jake Webush that does the pretrial?
Yeah, Jake is the probation manager, so he would oversee the department of the pretrial and the post-conviction supervision. Yeah,
So,
along with me. Yeah.
okay.
Yeah.
In the future, it might be helpful to have that conversation either with you or Jake, just to get an idea of because district court does have a lot more tools at its disposal, and what the time commitment and everything else is with that. So.
Yeah, I think we would both be more than happy to meet with anybody who's interested in meeting and hearing about it. So I think that's a great idea.
Okay. Anything else on topic of kind of updating where we're at as far as the risk assessment tool and monitoring?
Your Honor, I'm still a little confused on the community safety questions involved here. In the past, that's been an argument against releasing people, against using risk assessment tool. And now it appears we're releasing people on bail or into a pretrial services system that doesn't really have the capacity to ensure community safety, especially even in very, very obviously high risk cases. And I'm not sure where the points are that we could make any difference in that respect if we could. I mean, I guess we could not set bail for some people, but beyond that, I don't know the inner workings of the system well enough to posit responses, but it does trouble me that there are very, very high risk people out there who, other than a phone call once a week, maybe, are totally untethered.
I have the question. I mean, I don't really think people are getting lower bails with the pretrial monitoring. I mean, I think they're still getting, like, you look at someone charged with robbery in the first degree. I mean, they're going to get this money bail. I guess Dr. Peterson may be the person who's going to be looking at this to tell us ultimately, but anecdotally, I don't think that person charged with robbery is getting a lower money bail because there's the imposition of high monitoring. I don't see that happening, and I guess we'd have to reflect on it. So, I mean, everybody's entitled to a bail. So people are going to get a money bail set, and they should get a money bail set.
There are a couple exceptions to that, and one is the imminent threat of violent behavior, isn't it?
No. Everyone is entitled to a bail except for unless it's a homicide case. So, and homicide, special findings can be made, but otherwise, every single person accused of a crime is entitled to bail.
And I will say, when I look at when you look at the core rule and the two factors that you have identified as far as the risk to the community and violent offense and the failure to appear history, I think there's some overlap there. And that's part of the reason why I say in some cases, it does make sense to have somebody where bail is set. And if it is, and they post that they're still on pretrial monitoring as well, because it could go to their likelihood to reappear. And I think it may not solve the community safety issue, but it does help assure their appearance at future dates in my mind. And that's why I said in combination with the two, it can be helpful. But yeah, Ms. Donovan?
Yeah, I just want to be clear that my question was not to say that, I'm not saying that I think that the changes that have been made with the risk assessment and the creation of the pretrial services unit, I don't believe that those changes are increasing community safety risks, but I am wondering if those systems, and particularly pretrial services, could be expanded or used more effectively to help decrease community safety risks. So it's just, can we do better? Not we're making things worse.
I think that's a very fair question to be asking, how we can improve. I would also just respond just a little bit to Ms. Vanyo's point as far as, nobody's being released versus, bail being set versus pretrial services. And my understanding going into this, and again, I came on board about 1.5 years ago, and my understanding was this wasn't a tool that was meant to tell us whether we should be setting bail or not. It was more of an assessment as to, risk to the community, and it was really still the judicial officer's discretion when it came to bail. But in the alternative, if bail was not set, or in addition to, it gave us an idea of how we could better address both the community safety and the likelihood to reappear. And I think that's how our commissioners have viewed it in my conversations with them, as more of a supplemental tool with that respect. And if there is a case where they come up as a low risk, then it may not be determinative necessarily on bail, but it certainly helps them have guidance as to alternatives to it. So
I agree with that perspective, and with what Maya said as well. I really wasn't advocating for not setting bail for people.
Yeah.
What I was doing was expressing some discomfort with the holes in the net for once somebody was out in the community for monitoring people who obviously posed a potential risk.
Yeah. Well, I think that's a question, and honestly, when it comes to how we're doing and how we can do better, that's where I want to look at the district court model as well, and also probably Ms. Donovan's perspective and what she's seeing in the municipal courts with this work group. Anything further, though, as far as our current status with the use of the risk assessment or pretrial monitoring? All right. It seems to me that we have a few action items before our next meeting that we should talk about and address on how we're going to go about doing that. I would say, first off, it sounds like, Dr. Peterson, that we should have new numbers coming in relatively soon.
Yeah, it shouldn't be too long. I expect our quarterly update at the the beginning of October.
Beginning of October.
Yeah.
And would you be sending those out to the group when you receive those and can analyze those prior to our next meeting?
Sure, I can do that. Absolutely.
Okay. And the reason I
Awesome.
ask is because I think the second item that I'm looking at is then how do we have the community engagement that we had talked about, and how do we process what we've implemented? And I think part of that is having the numbers to see where we're at. So I would say with Stephen, that yourself, as well as Judge Garrett and myself, we should, I think at this point, maybe reach out to Adam and Dr. Johnson and set a meeting up with them, preferably after we get Dr. Peterson's numbers in early October.
Yeah, I think that sounds good. And if you want me to try to do a first draft of outlining what we're hoping for and working with them, I'd try that.
Oh, that would be great. I would really appreciate it. So would Dr. Johnson. So, yeah. So I think that covers those two items. And then the other aspect that Carol has brought up, and it's something that I've had an ongoing conversation with our commissioners, and I think with Dave Reynolds over the last 6 months or so, is just what we see as far as improvement and where we can adapt and make this as impactful as it can be on the true goal of incarceration reduction. And I think part of that is to examine what we're doing or what is being done in district court as well. So, I think I'd like to maybe set up a meeting with Bruce and maybe John and Dave to just kind of check in with the district court model and evaluate how that works and what we can incorporate in Superior Court if we can.
I just dropped out of the meeting for just a second. So I just heard the word probation. So was there something there that needed a response from me?
Well, I was just suggesting that it might be beneficial, with Carol's concerns and things that have been brought up and how we can adapt and make this the most impactful, that we can as far as pretrial monitoring, and actually look at the true goal of incarceration reduction, that we involve district court and maybe have a conversation and hear from district court on your methods and how that's being done. And I don't know whether that's a meeting of the whole and whether we should just bring in, Jake or yourself to talk about that, or whether we have a group, maybe including Maya and Carol in that discussion. So I don't know if anybody has an opinion on that, but I think if we really are looking to improve the system, then we should involve district court and their methodology.
Well, I can tell you that we would be interested in participating in a meeting like that. Is this something that would be arranged at do we have an action point at this time right now? Like, is someone being assigned to set it up, or are we going to make some decisions beforehand, kind of thing? I'm just trying to figure out where.
And that's probably where you dropped off. I was suggesting that there should be an action point, but I was leaving it. I kind of put it out there to the group as to how we go about doing that, whether that is as a presentation at a work group meeting, or whether it should be a smaller group to have that discussion first. So I don't know if Maya or Carol have an opinion on that, or Dave. If not, we could, I see Dave unmuted.
I don't have an opinion on it.
Okay. I mean, we could just plan on that being more of a presentation at our next meeting, if you were comfortable with that, Bruce, or having Jake do that.
Sure. Yeah.
Okay.
Yeah, that would be great.
And I can coordinate you in the meantime with kind of what we're looking for.
That sounds good. Yeah, that sounds good.
Okay.
Bruce, just really quick, can you tell us what how like weekend or after hour violations are monitored and dealt with?
Was that question directed at me, Dave?
Yeah, it was. Because could you just briefly let us know how after hour and weekend violations on EHM are handled through district court?
Yeah. So they are. The probation department receives the violation reports within about a 24-hour period. We can get a midday. When we come into work, often the beginning, first thing in the morning, there are some that will have been sent, and we would have received. And at that point, we would take action in terms of evaluating, based on criteria that we already have set, what action might be taken or not taken. And the action would be whether or not to send notice to the court that or set up a violation hearing that an alleged violation has taken place based on whatever it is we received from the sheriff's office. And then we have a bit of a very similar procedure for the friendship diversion cases for the municipals. But it sounds very similar to what John had mentioned earlier about the process that Superior Court has. We don't have a 24/7 ability to respond to the alleged violations and the reports that we get. They're handled if we receive them during work days, during the work hours. We can respond the same day in terms of bringing them in for an appointment. It could be breath test or urinalysis testing. But on pretrial, most of those are going to, for most of those, with the exception of they need to plug in their machine, or they need to bring their machine in for like a repair kind of thing, or some sort of tweak. But if there's an alleged violation of actual use, those are probably at a minimum going back to court for review by the judicial officer. Did that answer what you were asking?
Yeah, and I mean, I guess to put it in a nutshell, that you may be getting information about violations that happen 24/7, but you're not able to respond. 24/7.
Exactly.
If you get a violation from a Friday night, you're not going to know about it until Monday when you come in. So it's,
That's correct.
yeah, okay, thank you.
Carol?
Well, the other significant piece to the response, though, can happen in some circumstances directly between the monitoring company and law enforcement. So one of the ways the municipal courts specifically use the GPS monitoring would be to enforce conditions on a no contact order that prohibit someone going to a specific location. And they do have the capacity to directly dispatch law enforcement or connect with dispatch to have law enforcement respond to a no contact order violation. So which would be, so then that process goes directly into a possible arrest or criminal citation without having to wait for a probation violation to be filed and a court appearance. So it's not a fail-safe system. There's not a 24/7 response to a device not being charged or being tampered with. I always tell people who feel protected by this system to not count on it. But we have had many, many, many circumstances where there's been a no contact order violation over the weekend that has been picked up by the GPS monitor, reported directly to law enforcement, who has the ability to respond 24/7.
And that's through use with friendship diversion services, correct?
Correct.
All right. Anything further on that topic?
I just one thing further, outside of a no contact order, what authority would have law enforcement have for a violation of any other condition of release for somebody on GPS? I don't know they have the authority to do anything.
Yeah, I wouldn't imagine that scenario. The one that I have seen in municipal courts simply has to do with, and the way the municipal courts use it is a GPS restriction instead of the way we've always typically seen it over the years was always almost a home detention scenario, but municipal courts use it as an exclusionary. So they'll set up a perimeter of areas where the person is not supposed to be. And when that comes up as a violation, it's my understanding that's when they report it to law enforcement. But
I get my point. There's other conditions which they're not going to be able to do any enforcement on.
no, that's correct. But it is specific to Carol's concern as far as the DV cases in particular. Anything further? I think those were the action items that I had noted. Were there any others that were raised during our discussion today that we should note for future meetings? If there's nothing further, then I'll turn to Jill and ask if we have any public comment.
We don't have any attendees at today's meeting.
Okay. As far as our next scheduled meeting, I don't have that up in front of me. If we have a scheduled meeting.
There's a meeting scheduled on October 19th.
Okay. So that should give us sufficient time to get Dr. Peterson's numbers by then, and hopefully have a chance to meet with Adam and Dr. Johnson.
Judge, I hope that's the case. I'll keep you updated.
Yeah, please do. If that's not the case, we can look at if we need to moving that meeting as well to be more productive with it, I think.
Sure, sounds good.
Right. Anything further, or can we adjourn? All right. Thank you, everyone.